Often clients ask, what other documents do I need as part of my complete estate plan? Well, it really depends on the individual's circumstances. In many cases, a will, powers of attorney are sufficient. In some cases, a trust and wills and powers of attorney and living wills are appropriate. Generally, in a complete estate plan, we prepare a number of documents. The cornerstone of an estate plan is typically a living revocable trust agreement. That's the agreement into which all property of a decedent is placed during their lifetime. They manage their property during their lifetime, and then after they're gone, the successor trustee steps in and manages that property and distributes it to the persons entitled, the beneficiaries of the trust. In an estate plan, we also prepare what are called pour-over wills. It's kind of a funny name. The wills are there to do exactly that, though. In the event that property is not funded into the trust during the decedent's lifetime, that property is then placed into the trust via these wills. So in other words, a pour-over will is a catch-all. It sweeps all the other property in and places it into the trust. In a complete estate plan, there's also generally a need for general durable powers of attorney. A general durable power of attorney is a very important document, and it's a very powerful document too. A general durable power of attorney is a document by which a decedent, in other words, a person who makes it, can designate an agent or a person to act for them in the event that person, the decedent, is incapacitated. So in other words, if I name my wife as my power, as my attorney in fact, in my power of attorney, and I become incapacitated for a short time or for an extended period of time, my wife steps in and can do anything with my property that I could do. She can sell real estate, she can withdraw from bank accounts, she can deposit into bank accounts, she can lease my property, she can rent commercial property. Anything that I can do, my power of attorney authorizes my attorney in fact to do. The benefit of a power of attorney is that it eliminates the need to go to court to secure the appointment of a guardian or conservator to do exactly the same things. And a guardian or conservatorship proceeding can be time-consuming, it can be costly. So we recommend strongly that everyone have a general durable power of attorney. For the same reasons, we also recommend that our clients have medical powers of attorney, so that the attorney in fact can designate, can provide proper medical care for the principal, for the person who makes the document. And then finally, we generally recommend that people have what are called living wills or declarations. Now, a living will is not to be confused with a last will and testament. A living will is very different. A living will is a document that's provided by state law, and in this document, a person can specify what kind of medical care they want in the event they become terminally ill and are unable to make those choices to themselves. In other words, you can tell your family what you wish to happen to you if you become terminally ill. And the benefit of that document is it relieves the pressure on the family from having to make that decision about your care. They know what your wishes are. So, in summary, a complete estate plan generally consists of a living revocable trust, powers of attorney, both general durable powers of attorney and medical powers of attorney, and a living will or